The federal government of Nigeria has given the Supreme Court 13 grounds to block the indigenous people of Biafra's leaders release Mazi Nnamdi Kanu. Welcome to this wonderful channel, wonderful people. You are right back in News Info TV, where we bring you nothing but the truth. If this is the first time you are joining us on this channel, please, my brother, my sister, hit the subscription button, the like button, the share button, and also remember to on your notification button so that whenever our news drop, you will be the first to take it. All right, let's dive into the news proper. The Nigerian government has added 9 grounds of appeal to the 4 hurriedly filed last year to block the release of Nnamdi Kanu, leader of the indigenous people of Biafra, from custody. The Court of Appeal in Abuja ordered Mr. Kanu's release from the custody of the State Security Service after dismissing the charges against Mr. Kanu in October last year. The treasonable felony and terrorism charges related to Mr. Kanu campaigns for the secession of Southeast Nigeria and other rebellion places as the Independent Republic of Biafra. Mr. Kanu, who initially fled the country around September 2017, pausing his trial that started in 2015, was apprehended in Kenya and brought back to Nigeria under controversial circumstances in June 2021. Of course, you know that Mazi Nnamdi Kanu Ohamadike 1 of Ndibo was extraordinarily rendition from Kenya and was brought back to Nigeria, where he's continuing his trial. And the appellate court has, discharged and acquitted Mazi Nnamdi Kanu. They have struck out all the charges that were preferred against him. But as it stands, the Supreme Court has decided that Mazi Nnamdi Kanu will not be released from detention, which is very bad. It is very bad that a government which is supposed to uphold the rule of law is now countering the rule of law. Yes, if you make a law, you should be an example of what you have said. They say that leadership is by example. You don't make a law and at the end of the day, you start thwarting the law that you have made already. So why is the Nigerian government not obeying the Supreme Court in order to release MNK? It is very bad. Very, very bad. The government that enacted law, the government that instituted law, should be the first to obey that law. Of course, if there are other charges against Mazi Nnamdi Kanu, what should have happened is that the Supreme Court has discharged and acquitted him. Yes, they should have released him first before start pushing other charges against him. But as you know, there are no other charges against Mazi Nnamdi Kanu because this is pure politics. This is pure African politics. And African politics is very different. I don't know. Africans, some of them go to school, claim that they are learned, they are wise, they are lawyers, they are judges, they are attorneys. And at the end, they act like people who have not seen the 4 walls of the primary school. Meanwhile, some of these people have seen the 4 walls of the university. They have attained a doctorate degree, master's degree, this, that, and that. But I thought that education is meant to eradicate ignorance. But why are Africans still living in ignorance, especially Nigerians? And if you ask me, I will say that this is pure wickedness to humanity. Because you enacted a law, you set up the judiciary, and you agree that the judiciary should be obeyed. And now it has reached your own turn. You have decided that the judiciary, the ruling of the court has no stand because it is going to affect you in one way or the other, or because you are in the higher echelon of power. And you now decide that you can thwart the ruling of the court of law. This is one thing with Nigerians, Nigerian politicians, and some, should I say some Nigerian politicians and some African politicians. Look at what is happening in Sudan just because of personal interest. Because somebody might be thinking that what is happening in Sudan is as a result of saving the government. It is not even in the interest of the citizens. The citizens are suffering. They are lavishing in hunger because now the airport has been destroyed. No, there will be no more importation. So tell me, what are they going to do? Because the airport has been destroyed and many people are running away. Let's continue with this news. The treasonable felony and terrorism charges related to Mr. Kanu's campaign for the secession of Southeast and other neighboring places and independent state of Biafra. The shady mode of bringing him back to Nigeria was cited by the Court of Appeal as the basis for dismissing the charges against him and ordering his release in October 2022. But to block Mr. Kanu's release, the federal government hurriedly filed a foreground notice of appeal against the Court of Appeal's decision at the Supreme Court. It then approached the Court of Appeal to suspend the execution of the order for the release of Mr. Kanu from custody pending the Supreme Court's decision on the competence of the charges. The court granted the federal government's request, allowing it to pursue its appeal at the Supreme Court while Mr. Kanu remains in custody. Having gained enough time to strengthen its appeal, the government has now filed 9 additional grounds to the 4 it filed in the wake of the Court of Appeal's 13 October 2022 decision discharging Mr. Kanu. Laying the basics for questioning the decision discharging Mr. Kanu, the government said the Court of Appeal was wrong to have only considered the procedure of the IPOB leader's extraordinary rendition from Kenya without examining the gravity of the alleged crimes he was being tried for. Below are the highlights of the total 13 grounds of appeal on which the federal government anchored its appeal. First ground. In ground 1, the government said the Court of Appeal erred in law by allegedly failing to consider the relevant provisions of the Administration of Crime Justice Act ACJA 2015, a law that regulates criminal proceedings in federal courts. Citing Section 221 of the ACJA, the government argued that the Jumai Sankey-led 5-member panel of the Court of Appeal failed to give legal effect to the law, which stopped court from entertaining preliminary objections to the charges at an interlocutory stage. Second ground, the government queried the appellate court decision on the basis that it refused to be bound by established judicial precedent laid down by the Supreme Court on the mode of entry of defendant charged with the commission of an offense. The federal government contended that the Court of Appeal caused a miscarriage of justice when it held that Mr. Kanu's extraordinary rendition from Kenya is unlawful. Citing the case of Patrick Njovens and others v. the State 1973, he said the appellate court decision was a clear departure from the precedent set by the apex court. The government further said the Court of Appeal misdirected itself when it relied on the matter of Mr. Kanu's extradition in robbing the trial court of its jurisdiction, adding it was inconsistent with the judicial proceedings of the Supreme Court. Third ground. On another ground, the prosecution said the appellate court was wrong to have relied heavily on international legal instruments and case decided from foreign jurisdictions in arriving at its decision, freeing Mr. Kanu. It contended that the court's reliance on foreign laws like the Organization of African Union Charter on the Prevention and Combating of Terrorism as well as the African Charter on Human and People's Rights was at the expense of law governing criminal procedure in Nigeria. The court below misdirected itself when it gave binding force to treaties, conventions, and foreign judgments that are inconsistent with our Nigeria's legislation, the government filing said. Fourth ground, the government complained of being denied of a fair hearing by the Court of Appeal. It said the appellate court justice failed to determine the competence of Mr. Kanu's preliminary objection to the competence of the charges against him, thereby denying the government the right of fair hearing. The nature of entry of the respondent, Mr. Kanu, is not relevant in determination of the merit of the charges the government substituted. The fifth ground, contesting the court's order releasing Mr. Kanu, the government argued that the appellate court erred when it held that the Federal High Court lacked jurisdiction to try the IPOB leader because of his extraordinary rendition from Kenya. There was no evidence led by Mr. Kanu before the court of first instance, and the court below show how he was allegedly abducted and rendered to Nigeria, the government said. Referencing Section 94 of the ACJA and Section 32 of the Terrorism Prevention Amendment Act 2013, the government argued that the Federal High Court was clothed with adequate jurisdiction to hear the case against the separatist leader. It further argued that the mode of bringing Mr. Kanu back to the country cannot vitiate the criminal charges of treason, treasonable felony, and terrorism pending against him. The government told the Supreme Court that the IPOB leader was standing trial at the federal court, but floated the orders of the court and jumped bail. However, Mr. Kanu blamed his absence from court on the Nigerian military invasion in his home in Abia State. My people, now so I go stop. Una know as it happen. Now still on News Info TV now where you dey. And if not the first time we say you join us for this channel, I beg my brother, my sister, make you hit the subscription button, the like, the share button, so that whenever our news drop, it will be the first we'll collect. And God bless you for listening.